me. Afternoon, Judge.
Afternoon, Mr. Malema, Commissioner Malema.
Do you think that it is correct for a judge to look up to a politician for a decision whether to be in business or not? A judge that is applying for the highest court says to us here, a minister will tell me if I must leave business or not. Do you think it's correct to even say that?
Oh, I think the Act requires the Minister of Justice to approve the holding of any other office or source of remuneration. The Minister can confirm that.
But for you, morally and otherwise, we just heard here that you have listened to a case of that involves Standard Bank. And we hear in the same spirit that you've got shares in Nedbank. You might be biased in a sense that the decision you take on Standard Bank will have implications on Nedbank, and it can therefore influence or affect your shares. Looking from a distance as a layman, what must I make of you with such interest in business?
Well, I don't have an interest in business. I think if you go around and ask judges, many judges have investments in many institutions, and if you look at the registry of judges' assets, you'll find those disclosures there. I have shares in Standard Bank, I have shares in Nedbank, and so punishing the one or the other is not going to make any difference. In fact, they're furthest from my mind. And in fact, the judgment against Standard Bank, it never crossed my mind that my shares would be affected at all. You know, Mr. Malema, this issue of judges and their judgments affecting the share price was actually very much more topical when we were in the labor court, because a judgment saying that a strike was lawful or unlawful had a big impact on how the company operated. This is insignificant, and I think most of us have retirement annuities, and one way or the other, our pensions are invested in the PIC, which in turn holds shares. So the proximity of my decisions to these entities is just so far removed that it's not an issue.
You might understand that not to be an issue. The banks have become a big problem in this country. The banks have become too powerful in this country. And for a layman who litigate against banks, which in most cases will against us, and sitting from a distance and knowing judges have got shares, worse in all banks, because you even went beyond, now you've got 2, 3, Nedbank, Standard Bank, and all of that. Banks win cases against us, and judges have got shares in the banks. It doesn't matter whether it affected your judgment or not. Justice must not only be done, it must be seen to be done. I'm sitting in a village in Mkomeni, in Butlokwa, in Limpopo, and I hear that judge who presided over my matter against the bank actually has shares in the bank. What does it do to my brain? I've got no education, I've got nothing. I don't know how it works in terms of shareholding or being a business person in the banks, but we just know business to be shares. You've got shares in the banks, you preside over matters that involves banks, and you rule in favor of banks against ordinary individuals. Does that help to enhance the good image of the judiciary?
Mr. Malema, I think the practitioners in my division will tell you how I lambasted the banks. Standard Bank, for instance, comes to the High Court with a claim for 10,000 rands repeatedly. 10,000 rands is the cost of hiring an advocate. Why are they litigating in the High Court? The reason I get is, or the explanation that I get is that the banks are chasing returns. So they have a panel of attorneys, and you've got to perform, you've got to deliver. And so the more you litigate, the more revenue you bring for the banks, the more you are used. But it doesn't cut it in my court. They also litigate for amounts that should actually be in the courts below, magistrates court, district courts, and so on. And I have repeatedly transferred matters there, and I've invited them to take me on appeal. I've given them 6 reasons why they should not be in the High Court. Of course, that increases the cost of litigation. In the 2 matters where there was this 10,000 rand claims, the litigants were, in one instance, in Port Shepstone. The case is being heard for 10,000 rand in my court in Durban. And they were expected to make that decision. They can't pay their debt, let alone get to a court. So I can assure you, if assurance is needed, that the banks really don't think I'm their friend.
Judge, you see, that's the problem, because we are now being extremely subjective because of your involvement with the banks. I'm saying to you, and we have to get this point very clear, not you. Remove yourself and your shares and your interest from the bank. I'm saying to you, would it be in the best interest and in the good image of this judiciary to have judges having shares in the banks and ordinary people litigating with banks and losing? We're not saying you are judging in favor or not, but we know in most cases our people are losing against the banks because they don't have the muscle to fight the banks. And they later hear that actually the judge so-and-so, Judge Mpofu, is a shareholder in the banks where they were litigating against. Will that help to enhance the good image of the judiciary? That's what I'm talking about. We're removing you now.
Commissioner Malema, I think if you look at the JSC, where most of our investments are, all of the corporates are in one way or the other infringing on one or other rights of workers, of the people, because these entities are in the business of making profit, whether it's Vodacom or MTN. The complaints about, well, the Constitutional Court had a Vodacom decision to make, but data pilferage, abuse, all of that, big companies, they do it. So whether it's a bank or whether it's a utility, whether it's a mining company, all have skeletons of one sort or another. So if someone can find a safe place where our money can grow for our retirement, our RAs can be invested, I think we can all rest more comfortably. But we can't manage our money. We can't be in business and make our money grow. We have to put it into fixed deposits otherwise and hope that inflation doesn't eat it up. But that's the state of play. And if there's a collective decision that we must not invest in particular entities or in particular forms, I'm happy to abide by the collective decision. But
well,
there we are.
I take it to my. You're not going to answer my question. I had someone of the lawyers saying there's something called evasive. So there's something that sounds like that. Let's leave it. Is there a picture of you and Hanekom and Godan circulating?
You mean together?
Yeah, together.
I've never taken a picture with Mr. Hanekom.
Do you have a picture with Mr. Godan?
It's possible.
What's your relationship with Mr. Godan?
I've answered that. I'm a friend of his. We've been friends.
Do you think it enhanced the good image of the judiciary to have judges befriending politicians?
Unfortunately, it's not a relationship I can dissociate myself with, for the simple reason that he has been my friend from a long time, and I cannot deny that. It's never, the fact that he's been in government has never interfered with my adjudicative work. And he and I recognize boundaries. Politicians recognize boundaries with the judiciary. In the IEC, I interact with many politicians, and there are boundaries.
Judge, when you interact with us in IEC, you're not our friends. We're not friends.
I know.
Yes, I'm talking about friendship, and you shouldn't deliberately distort what I'm asking about. You are a friend of a politician called Pravin Gordhan, who is alleged to have captured judiciary. And I'm asking you, does that help to enhance the image of the judiciary? And you never answered the question on your practices, if whether these practices are helping to boost the confidence of our people on the judiciary. That's what I'm asking about.
Okay. So if that's the part that I've evaded, I thought I had answered it. My answer is that I don't think, I don't know enough. But if somebody sitting in the rural area has the interest in my holding shares in Nedbank, I seriously doubt it, because I think my work as a judge should not be determined by what shares I hold. But if it is a problem, we can talk about that. As far as Gordhan capturing the judiciary, as you say, it's allegations. If there's allegations, they must be tested, put up the evidence, bring it to a process, let's investigate it. I'll be happy to participate. Allegations out there is just allegations. Sorry.
No, I'm saying, you being a friend of a politician, does that help to boost the good image of the judiciary? I'll tell you why. There are judges that I've known from when I was young, and when they got appointed, I disassociated with them for their own protection and for the protection of the judiciary, because there shouldn't be a story that they are friends with politicians and therefore they conduct themselves in this or in that way. And you are saying you will never terminate your relationship with Gordhan because it comes from a long way, even if it damages the good image of the judiciary, because from that friendship, an impression can be created that Gordhan is influencing you and you are influencing others to rule in the favor of his faction.
Commissioner Malema, you asked me what my relationship was. And in the broad nature of defining a relationship, I use the word friendship. Yes, we have been friends, but my association, and it's never impacted on my work as a judge for the past 21 years, and it will not impact on my work going forward. I've made judgments against Treasury. I've made judgments against SARS, and it's never been a problem. But friendship doesn't necessarily mean that I'm having breakfast, lunch, and supper with Mr. Gordhan. Our association has drifted over the years, precisely because, well, COVID has also been part of it recently, but over time, the two of us, when I spoke of boundaries, this is what I mean. My association with people who have been my friends, who are now politicians, have distanced themselves from me precisely for this reason. They don't want to compromise me. They respect the judiciary. They respect my role in it. They want me to be in the judiciary. Many of them have supported me in this endeavor in this application. And so they know where my heart is. And they know that my heart is not with politicians, but my heart is with the people of South Africa for whom this Constitution is meant to serve.
I didn't get the impression first time because I thought the constitution was coming after the relationship with Gordon. Thanks for the clarity. The other question, after the lunch with President Zuma and going to preside on his matter, did you declare to the parties involved that you had a lunch with President Zuma? And after declaring to the parties involved, did you declare in the public court for us, the public, to see if that will not be a problem for us? Because you cannot go and have a lunch with a person and before you know it, you are hearing a matter involving the same person and you don't tell us, because I want to tell you now, if I knew you had a lunch with Zuma and you declared it publicly, I would have made an agent application to join that court and ask for your recusal, just for that reason.
No, quite right. If I was in a social engagement with Mr. Zuma, I was having lunch with him as one friend to another, I would have disclosed it. I was in an official engagement, and as part of my official duties, I didn't think it was important to mention all my official engagements. It's a matter of public record. And I would have assumed that Mr. Zuma would have instructed his counsel to apply for my recusal, if that was a problem. I anticipated an application for a recusal for one or other reason, but both parties were very happy to have me. And in fact, there was a high level of collaboration by both counsel with each other in the proceedings. They made my work infinitely easier because there's no dispute of fact. There's no dispute of what law applied. The issue was for me to decide whether this appeared in the tweets, I think it was, and this having been said, does it amount to defamation? That's all I had to decide, and that's what I decided. Both parties knew my background, I assume, and there's no secret about my associations. So there was no application for my recusal. I did not feel conflicted. And this is the thing about the law. You focus on the law, nothing else matters.
Ma'am, the public court doesn't only belong to the litigants and you. It belongs to us. And whether Zuma was happy with you, maybe he thought because you had lunch, you can deliver something. I don't know. That's why he didn't object to you. I don't know why Hanagom didn't object to you. But I'm saying, we, the public, coming to hear now that you had a lunch with Zuma and you didn't have the courtesy to tell the public that is also interested in the matter, that please, if it comes across one day that I went to Nkandla to have lunch with Mr. Zuma, please be aware I did. Don't you think in the judicial wisdom, it was necessary to take us, the public, into confidence?
Ms. Malema, if I did not mention here that I had lunch with Mr. Zuma, very few people would know about it. I don't mind the public knowing. And I'm happy to disclose everything about my relationship with Mr. Zuma or anyone else you want to ask me about. But so here I am disclosing, and if I had something to hide, you should be worried.
Again, you're not answering my question, because I'm talking about a case, and that case even involves monies that people are going to have to pay. I'm not talking about these proceedings. I'm saying in the judicial wisdom that you claim to possess and you want to go to the highest court, don't you think on a higher side now, you should have made us aware, not because you want to go to the constitutional court, but in your execution of your duties honestly, that because this is a high-profile case, it involves high-profile people, please be aware that I had lunch with Mr. Zuma, or put differently, do you know what it was going to cost if someone had leaked your picture with Zuma during lunch after hearing that matter, even before you delivered judgment? That remember, this is the judge who just had lunch with Zuma before hearing the matter of President Zuma. Do you know what damage was that going to do to the judiciary. Worse if you didn't declare. Because if it comes through other sources, it's like a breaking story. But if it is declared by you, it's fine, it's well and good, it's clear, you have nothing to hide.
Well, that's what I thought I was doing. I mean, I didn't have to declare, but as I said, I was on official duty with Mr. Zuma. And if a picture appeared in social media, it wasn't a problem because that's what social media does. And whoever wants to spin a story around it would. It's a question of to what extent we buckle under the pressure of social media and to what extent decision makers are able to separate the noise from the reality, which brings me to reminds me of another book, Mr. Malema. It's a book titled Tough Cases. And a group of judges in America got together and wrote about their tough cases. One of the tough cases, and if you Google now Elan Cuba, you will see that that was one of the toughest cases of the judge presiding in that matter. It was a case of this youngster who escaped with his mother from Cuba, and the American court, that this particular judge sitting alone had to make a decision about that, where that child's custody lay. It became an international debacle with the media camping on the child, where the child was living, and the judge had to cut out the noise of the public on the issue and focus on the law. It gets tougher and tougher to focus on what we are meant to when there is this noise in the media, these allegations. I hope I've answered you.
No, you didn't. Chief Justice, I'll move. What is Morogoro Consultative Conference? Whose consultative conference is this one?
I think there's an ANC Morogoro conference that Kalinicus refers to in her book.
So a judge quotes a political party's conference document in a judgment. What do you call that if it's not a judicial capture?
Are you referring to Tamba's?
Yes, Morogoro. We are quoting Tambo's closing address of a political party gathering in a judgment that belongs to me. It's not your judgment. Once you pass it, it is the judgments of our courts. And I must also quote it confidently and rely on it. But it's quoting a political speech given in a political party gathering, not Mandela's speech given at the Union Building, accepting to be a president of the Republic of South Africa. The two are different. This is a political party gathering. You confidently open a judgment with it. What do we call this?
Well, as I explained earlier, that I quoted that because that is the president of the litigants before me. And if I didn't make sense in my judgment, and I did say to them in the judgment that this is a conflict over which I have no reach. And so by quoting that, I was alerting them to their president, and hopefully they would listen to their president, look to themselves to see how they could overcome their conflicts. So I quoted it from literature. It's a biography of the president of the ANC. So it wasn't meant for anybody else, it was meant for the parties.
Judge, you knew what you were doing is incorrect. That's why you didn't write. It is called, I asked you deliberately because I know it. It is called ANC Morogoro Consultative Conference. And you knew that it will be inappropriate for you to quote ANC documents in your judgment. You deliberately omit the ANC so that people will not even know that a judge of a neutral court quotes a political party gathering documents in her own judgment. Yet we must still perceive you to be a neutral and objective judge who's not biased. Judge, I'm going to argue in this in a closed session, that you are nothing but a political activist. You are no judge and you deserve no high office If anything, you also factional and belong to Pravin's faction, and you are pursuing factional battles using the bench. Will I be fair in that criticism?
No, you won't. For your information, Mr. Malema, I refused leave to appeal in the Hanukkah matter. It went to the Supreme Court of Appeal, who refused the petition. It went to the Constitutional Court, and the Chief Justice also was party to the decision refusing leave to appeal. So if I misbehaved in any way, there was every opportunity for the court sitting over me to call me to order.
Thank you, Chief Justice, and thank you, Judge. Thank you, Chief Justice, for being patient. It was necessary.
Thank you, Honorable Malema. Commissioner Tsepe.
Thank you.
Judge, I take it that you support transformation.
I do.
And when you genuinely look at the list of the people who are coming here, who have not had a privilege like you did, and you know that some of them are so well capacitated, they may not have the same education as you, but even with such a poor education that was given to them by the apartheid government, they managed to rise through those difficult situations. And as a supporter of transformation, why don't you just say, you know, guys, let me pull back and allow my brothers and sisters who have worked so hard to be where they are to rise, and perhaps in the second round or so, I may try my luck, because we shouldn't support, and you agree with me, transformation when it doesn't involve us directly. But when it is us who are now involved directly and we stand a chance of going through, we now want to apply the issue of transformation from a theoretical point of view, not because we believe in it since we are involved directly. So I thought someone who support transformation will look at the list we have and say, you know, there are a lot of potentials here. We know we've got that duty, we'll choose the best ourselves. But as an activist and as a supporter of the transformation in the judiciary, you also have a duty to say, thank you very much, I applied, I'm here. But I think that given my background and looking at the list we have here, let me step back and allow my brothers and sisters to emerge. And in that way, you don't have to give this body a difficult job of having to choose between you and those who are less privileged.
You know, I agree entirely that that people who come before you who have had hugely disadvantaged backgrounds and have got to the level of that they have, with the achievements that they have, is astonishingly wonderful to see. I mean, you know, we celebrate people who can achieve things from disadvantage. And you're correct. I have certain achievements, but I certainly had many advantages in getting there. And you could say, well, that should end the debate. And I take your point also that one mustn't be theoretical about transformation. It's you know, it mustn't be it's fine until it affects you, and then it doesn't. Then it's no, you know, then it's put to one side. I agree. I think though that one does have to give some thought, I do, to what transformation means in its different parts. Certainly one part of it is that our courts must look like South Africa, and that's a key feature of what happens, and I think we've made some progress as far as that's concerned. I think the second thing is that transformation is also about harnessing all the talents of our people and making sure that they are represented in, amongst other places, our courts. But I do also think that transformation is about, it's a quality of your mind as to how you think about the world. And I think there are ways in which transformation works through the kind of chemistry of what you want to do together. And that is not just about saying, well, we must necessarily prefer X over Y. It's about saying, I want to constitute, for example, the Constitutional Court in a way where the larger constitutional project of transformation is best likely to be achieved. I can only say to you, as far as that's concerned, that I see this through the lens of service. You may reach the conclusion that ultimately I can best serve in another role, and I will understand that position, and that may mean I should step back in your judgment. But I think there is also a way in which one can think about constituting a court where the attitudes of mind and the desire to make this court something special is one where I could still be of some service. And it's only in that sense that I would ask you to think about my role.
Judge, let me try to persuade you once more. You see, you come in for 3 years. You find senior judges there who have gone through difficult processes for them to be there. If this is not classical case of privilege, then I don't know what it means. You sit there with the beautiful education you got from a privileged point of view. In 3 years' time, you come and pass all these villagers. You come and pass all these people who have gone through poverty, who have gone to be where they are. You pass them and you go to the highest court and still come back to us and say, you know, privilege is not right. We want empowerment, want transformation, and we must still listen to that. When you couldn't on your own, right conscience, say, there are so many people that I found here who are well qualified. They may not have the same education I have because of the background of where we come from. But these guys have been here. These guys have worked hard for them to be here. And they are not as privileged as I am. Because we are going to be heavily criticized to choose a white male against a black African female who has gone through the ranks, who has interviewed so well, but she doesn't have what you have for obvious reasons. She's not from all these things that you are speaking about. They come as a result of the privilege you had. She doesn't have all of that. And in your right state of mind, you say, consider all of this and leave her. And you put us in that predicament instead of saying to us, you know what, I appreciate, and now that you have put this to me, my journey to this, at least for now, ends here. I don't think I must still be considered.
Yes. I think there are two points I would make, and I understand the position that you have. The first of them is, as some questions have already been raised, you know, you can't do everything in a lifetime. And, you know, at a certain point you reach an age and there isn't an endless runway before you to say, well, you can come back at another point, because at a certain point you can't. I mean, we all get older, and that's one of the things. So it's not one of these points where if I were coming to you at the age of 50 and saying, you know, I want some preferment now, I could understand that. One can only do so many things in a lifetime. So that's one point. The second is just this, I would never see it really as passing anybody. It's more a question of looking at what I may have to offer in terms of the things that I've done and the things that possibly I can contribute to this court. And saying, some of the candidates who have come before you and have got huge promise and ability will also, in their way and in their time, be able to make the contribution. And you will decide. You might say, well, we want younger candidates who've come from disadvantaged backgrounds to go forward and go forward first, and maybe you will never go forward. And I will appreciate that and understand that that's a judgment that can be made. But I think there's another way of looking at it as well, which is to say there are some candidates who come, they have some attributes and things to offer. We may want that because transformation is ultimately an inclusive doctrine about how we constitute institutions and how they can operate. And as I've said, we want to have ambitions about the court. We want it to be the crucible of talents. And I would love to give you an easy time in terms of making your choices simpler, but I feel that the nature of your task is the difficult one of trying to work out how that is best done.
Now, Judge, on a different point, do you think that judges being involved in business and having shares in big companies helps to build confidence of the judiciary and enhance its good image? And I'm talking about business and shares.
Yes.
Not bank accounts, like some senior judges were distorting us and not knowing the difference between shares and bank accounts. And coming from senior judges is so disappointing.
Yeah.
And people who are deliberately distorting us and sending us to jail out of deliberate distortion and misinterpretation of what you said. So we're talking shares and business interests, not bank accounts. There's no way a judge can have money in a house. And I would never suggest such a thing as a leader of a political party.
Yes.
So I don't want to go to that level of degeneration. So I'm just asking at the level of shareholding and judges participating in business, does that help to enhance the confidence and the good image of the judiciary?
Yes, I heard the question that you posed to another candidate, and I've been thinking about it since you raised the question. I think firstly there's a difference between holding shares and participating in a business. I don't think that judges must do judging. They mustn't be running businesses on the side. But that's not answering your main point, which is the fact that the judges hold shares a problem? I think the difficulty that we have, and I'm sorry I won't have a very clear answer for you, is just this, that almost everybody who belongs to a pension fund indirectly owns shares in businesses. Some people own them directly, and some own them through retirement annuities, and some own them by being members of a pension. You get a stake in companies. So I just don't know what the answer is, because I think judges, like everyone, have got an entitlement to save for retirement and have some security in retirement. But I'm wondering whether there's a way we should think more carefully, following what you've said, about, as happens in other jurisdictions sometimes, that they're put in what are called blind trusts. In other words, you say, here are the assets, I will have no connection to them. A trustee is appointed for the period of my office as a judge. They will do with them whatever they do, good, bad, or indifferent. And when I finally retire, I can either take them out of the trust or become involved in it. When I heard your question, that was the first thought that I had, which maybe that would be a separation of a kind that would lead the person in a village saying, well, I don't want them to have indirect interest in shares where maybe that company is then a litigant in court. I don't know if that helps.
I'm happy that there are still judges who hear when we speak. Thank you.
Thank you, Chief Justice. Just one question from my side, which obviously was prompted by your resignation from the Jewish Board of Deputies. It prompted me to want to get a sense in terms of your views on a two-state a solution to the Palestinian-Israeli conflict. You remember that in 1993, PLO and the Israeli government entered into an agreement to implement the Oslo Accord. So, not much more concerned about your resignation or your membership. That to me is not an issue. The issue is because as a country, in terms of how we relate to our neighbors or to the international global community, our entry point is Africa, and obviously EU has a position on the conflicts. What's your view on the two-state solution?
Yes, my position on that is that I consider that a two-state solution, although it is now unfortunately one that seems to enjoy much less currency than it did in decades gone by, remains the only solution that I think is both feasible but just in what is a hugely complicated and difficult conflict that exists.